So what is the, do you have a vaccine there? Is a vaccine being available?
Yes, vaccine is being available, and then it's start to be scheduled, administered. Myself and some of the community members also had a vaccine already, Rabbi.
Right.
But the, you know, I think the pace and the speed of the vaccination versus the virus mutation is not in par. We clearly have here the, you know, the mutation is going far more faster than the vaccine. Please God, everything will be okay.
I'm sorry to hear it. We should all be well, please God, all of you.
Amen, Rabbi. Yes.
Well.
Yes.
Indeed. Okay, now let me just give me 1 minute.
Sure, Rabbi. Okay.
One sec.
Baik, Bapak Ibu sekalian, sementara Rabinya mungkin lagi siap-siap dan lagi sambil membuat dirinya nyaman. Selamat datang, selamat pagi, Shavuot Tov buat kita semua. Kita akan lanjutkan kembali pengajaran kita bersama dengan Rabbi Shimon Cohen terkait dengan pembahasan detail 7 hukum Nuh, dan kali ini kita akan masuk bagian kedua daripada hukum larangan mencuri. Bagian pertama kita sudah selesaikan minggu lalu dan Rabbi sudah menjelaskan banyak hal, dan kali ini kita akan masuk kepada bagian yang kedua yang akan segera disampaikan penjelasannya oleh Rabbi.
Okay, now, all right. So today, I'll please goodness, I'll attempt to conclude the section on the Noahide law prohibiting theft. Is that all right? So, because we got halfway through last time. Okay.
Yes,
fine.
Rabbi.
Very good. Okay, well, I'm not sure of the exact point where we left off last time, but at all events, let me just see here. Now, 1 minute. Okay. But at all events, we know that the law of theft, it relates not simply to property, but of course it also relates to theft of the body. As a matter of fact, when we look at the 10 Commandments, which are actually part of the law given to the Jewish people, because the Noahide laws are not the same as the 10 Commandments. There's an overlap, but it's not the same. Anyway, the law in the 10 Commandments which prohibits theft is referring to theft of the body or abduction, taking a kid or kidnapping a person. There's another commandment in the Torah which prohibits the theft of property. But the law in the Noahide law of theft includes both. It includes both theft of property and also theft of the body. So this is a for example, a crime like rape has in it, apart from all of the other issues which may be involved in rape, there may be a whole host of prohibitions, forbidden relations, harm, injury, etc. All of these different things. But in addition, it also has a dimension of theft, because what it does is it takes the person out of their own domain, out of their own realm of control of their own body. And it's considered like an appropriation, an abduction of the body, as much as all of the other prohibitions, all the other issues which are involved there too. So as I mentioned in the case of the biblical story of the abduction of Dinah. Now Dinah was a daughter of Jacob, and Dinah was abducted. She was taken away by a prince of Shechem. And that was, and amongst all of the other things, it was also an act of theft, a theft of her body as well. Now, theft also applies to not only to physical things, but to non-physical things. For example, we talk about intellectual property. So for example, if a person has written a book, then there is a question of whether we're allowed to duplicate or replicate that book certainly for commercial purposes, or maybe because it has a copyright. Or for example, if a person has a patent for an invention, person invented something, and the individual has patented that invention, to utilize that without permission is a form of theft. Simply because that is because intellectual property is also property. I mean, it may translate into actual money. The person, and it very often will. It takes away the person's ability to earn with that copyrighted work or that patented invention. But this is also a form of theft. Now, also in the realm of theft, theft is not only the situation where a person took something away from another person. Theft can also apply in a situation where it did not begin by taking something away, but it is nevertheless owed to a person, and the person does not pay what they owe. And I'll give you and here, for example, one classic example of this is if a person worked for somebody. Now that person owes wages. So if the person refuses to pay the wages, that is a form of theft. The employer didn't take anything away from the owner, from the worker, because it's his own money, it's his capital, but he owes the money. And because he's not paying for a service which has been given or for work which has been provided, that's also a form of theft. Similarly, not repaying a loan. The money it certainly didn't start out as an act of theft, because if somebody lent you money, well, they freely lent the money. The money didn't come into the person's hands by theft. But if now the individual refuses to pay back the debt, then that becomes an act of theft, because the money is owed. It's owed to the lender. That's also. Now, so holding back wages, that's a form of theft. Holding back a loan, refusing to pay a loan, it's a form of theft also. But as one says, it's different from the earlier basic form of theft, which involved taking away something which the person never had, which was taking away without permission. Now, there can also be theft in a situation where one is a worker or an employee and one takes benefits which are not legitimate benefits, which are not benefits which were granted. So if, for example, the company has, these days it's not applicable because telephones telephone services are very cheap now, and everybody's got a mobile phone and so on and so forth. But once upon a time, it was very expensive to make a telephone call, particularly overseas telephone call. If an employee made overseas telephone calls from the desk of an employer and without permission to do so, then that could also, that in those days, that would have been that was questionable, and the person would need to pay back or be forgiven by the employer for that, to clear up that misdeed. Now, what about the situation where a person takes something forcefully and pays for it? Normally, theft means one takes something and doesn't pay. But a person could take property, take an item in the shop and put down, or take it from another person, maybe not from the shop even, but take an item from the other person's possession and put down the money on the counter, put the money on the table. Now, that person is paid for the item, but the seller did not want to sell it, did not intend to sell it. So that is also a form that is also prohibited. It's called, that's giving under compulsion. He paid, but the person paid for it, but it was the goods were given, the goods were actually taken forcefully. And this is similar to the situation where a person steals something and later on returns it or replaces it. In the long term, there's no loss of value. The person, it's been paid for, it's been restored, but there was no permission which was given in the first place to take it. And this relates also, as we mentioned before, to the idea of borrowing something without permission. Borrowing without permission is also a question, it is also a possible form of theft. Now, these forms of theft may not be as serious and may not be subject to the same kind of penalty in Noahide law as in the case where one takes something and does not pay for it at all, but still it's forbidden. And society is certainly entitled to devise various punishments and penalties for doing this. Now, there is also now a whole area of theft, which comes about as a result of deception. Once again, the classic form of theft is a person takes something, puts his hand in the other person's pocket, pickpocket, takes out money without the person knowing or wanting, or even if they do know, without their consent. Normally that's theft. It was done. There was no consent at all. But people can also consent. People can consent, but they can consent under conditions of deception. They can be deceived into consenting. And this, of course, is the whole area of fraud. Fraud is a situation where there was consent, but the consent was obtained through deception, through deceiving the other person. Well, there can be, for example, a very simple form of deception, fraud, is where a person, a shopkeeper, let us say, has altered the weights and measures, has tampered with the scales, with the weights and with the measures by which the merchandise produce is measured out. So the person, the buyer, sees, oh, this is a kilo. This is a kilo of produce, but the scales have been tampered with. It's not a kilo at all. It's only 3/4 of a kilo. So the person is okay. So the person, is paying. He's not. The money was not seized. The money was not stolen from the person, but it was given under false pretenses, under false. That is a situation of, that's where that is a fraud, that's an instance of fraud. Now, this obviously, this is something which is also prohibited. And outright, as a matter of fact, Maimonides says that this is straight out theft. It's probably quite. It's just like the holding back of wages is straight out theft. Nothing was taken in the first place without permission. But in each case, it is a wrongful acquisition of the other person's money. Now, misleading information, misleading advertising, deceptive advertising is also comes under this category, because quite simply, the person thought they were getting a good product, a product which was different from what they ended up receiving. So it was through misrepresentation and deception in the advertising, etc., or whatever it was, that this if you like, fraudulent transaction took place. As I mentioned last time, and in fact, there was a question. A question was asked, and I won't go at much length now. It is also we call Genevat dat, which means deception stealing another person's mind, misleading them, even if it doesn't necessarily involve money. It's deception. For example, somebody asked last week, what about misleading another person? Let's say a man is giving a woman a misunderstanding, a false impression that he wants to marry her. Is that that is a form of deception, and that's wrong. Whether that's the same as theft or not, I'm not sure. But there are many cases of Genevat dat, of literally stealing another person's mind, which do have sort of monetary ramifications. The example I gave last time was a situation where you go into a shop and there is a salesperson there, and one spends a long time asking the person all kinds of questions about the merchandise, and one has no intention at all of buying anything there. So that has misled the salesman to think that, oh, he's got a purchase, he's got a sale coming up, he's going to be $60. But there was no, in fact, the person gets the information and then goes to another shop and buys. That's also a form of misleading and literally of stealing the other person's trust or conscious or understanding. That is something which is also forbidden. If you want to go into a shop and you want to take half an hour of the salesperson's time in asking all of these questions, and you don't want to pay for it, then say straight away, I'm not coming here to buy anything from you, but I have a series of questions. Are you able to answer these questions for me? They can decide, but one should not take their time and mislead them into understanding that in fact you are going to make a purchase from them. Now, what about the whole issue of restitution for theft, which means paying? In other words, if a thief steals something, then a thief could be punished. A thief could go to jail. But what about actually paying for the item? Does the thief, is it simply a criminal offense and the thief is punished by, let's say, a jail sentence, certain time in jail? Or does that thief have an obligation to pay for what the thief took? Maybe the thief doesn't have the money to pay back. Maybe the item has been consumed or used. But then we could say, well, at least let the thief have a debt. Let the thief the thief has to eventually return what was stolen. Anyway, there's a lot of discussion. There's a lot of discussion of this matter in Noahide law as to whether theft is a matter which we deal with simply by punishing, or whether it also requires the thief to restore what the thief took. So, but the bottom line seems to be that in fact there should be restitution, and that the state should require of a thief not only punish the thief, but also and primarily perhaps require that the thief eventually restore, and if he can't restore the object itself, at least to restore the monetary value of what the thief took. In other words, the thief should have a debt to pay. It seems very right too. It's also in many ways a tikkun, a rectification for the thief himself. The thief has made good, so to speak, what he or she did. Okay, now so now we come to the area of damages. Now, damages are not the same thing as theft. Quite basically, let's, for example, there is theft of a motor car. But, and that is one thing, there's clear, if a person stole the car of another person, that is a clear case of theft. Theft means it was taken from the possession of the other person without the other person's permission or consent. But what about the situation where you actually damage the car of another person? You damage the property of another, where the other person's car is not stolen, but damaged. Is that the same thing as theft? Does that come under the category of theft in Noahide law? Now, according to the baseline, the basic view in Noahide law, it doesn't. And as a matter of fact, if we look back in history and even in the law of modern society, the concept of damages is something which is relatively new. And this is because people could have said, you watch out, you protect your own property from damage. Keep your property out of harm's way. That was a view which prevailed in society, traditionally, even in Western societies. That was a view which obtained. But it's certain, according to the second view in Noahide law, which is like Jewish law, it's not so. Damages, and in fact, contemporary societies around the world these days make people pay for damages. And according to the second view, damages are included in Noahide law. In other words, not where we take away the property, but where we harm the property of another person. That has to be paid for. Or society has to find some kind of a remedy for that. So, and of course, the same thing will apply to harm done to the body of another person. Now, in Jewish law, for example, there are a whole host of damages which need to be compensated when they're done against the body of another person. First of all, there can be the damage which is caused by the loss of a limb, or a fact that the person's body has been weakened by the act of another person. And then there is the issue of medical expenses. And then there is also the issue of unemployment. What happens to the person that the person is not able to work as a result of the harm done to one's body? And so there's that. And then there is another category which is called the idea of shame, embarrassment. It's called boishus in Hebrew. And then another area, what about the issue of tsar, pain itself? That the pain can be not just that there's a financial loss to the person as a result of having had this injury, can't work as effectively as once could, but what about the compensation for the pain experienced at the time when the injury was inflicted? So all of these areas, there are two ways like this. According to the first view in Noahide law does not actually set rules for this, but society can make its own conditions and terms and guidelines for the payment of damages. And there's something to be said that there are rational grounds certainly to say that it should do so. Okay, so this is an area of which I think we have to say, practically speaking, is now part of Noahide law, because most societies these days regard damages, harm to property, as something which has to be compensated, and so effectively Therefore, and it's a rational thing too. And society has certainly got the power to require these damages to be paid. So also, we come to the issue here of not just the harm of the body, but also harm of property. There are also subtle, more other forms of what we call intangible harm, which can arise. For example, privacy, the laws of privacy. Are you allowed to build a house in such a way that you can now look into the backyard of your neighbor? This is called in Hebrew law hezek re'iyah. In other words, the harm which is caused by having one's privacy reduced. Can you build in such a way that you can see into the other person's property and private area? What about also issues such as blocking the sunlight of another person by building there, and so on and so forth? Well, certainly society is empowered to make laws regarding this, and it could be that even according to the second view of Noahide law, the more stringent view, these are also areas which apply in Noahide law. These forms of more subtle harm, lack of privacy, lack of light, and so on and so forth, which one person can impose on another. So then also there's an area of negligence. Now, negligence was also not traditionally part of the Noahide law. I mean, when I say even Western law, even. And it was, it didn't say it was not part of the Noahide law. According to the first opinion, it wouldn't have been in there necessarily. So, do I have, for example, the issue of watching your own property that it shouldn't cause harm? If you have animals, are you obligated to make sure that your animals do not cause harm to others? A person has a dog which bites and attacks people. Do we say let the victim should have stayed out of harm's way? The victim should have watched out for such harm? Or do we say that no, the owner of the dog has got an obligation to see that this dog does not cause harm? So this is an area where which is called, we call it a duty of care. A duty of care. Now, this notion of a duty of care, as I said before, is something which came into Western societies relatively late in the piece. And it's certainly there in Jewish law and in Noahide law, according to the more stringent opinion too. But here we need to ask whether whether it should be a requirement of Noahide law itself. The answer is, it seems to me, yes. No, we are coming into a situation now where societies are much more conscious of the need for us not just not to hurt another person, to steal, but to watch out for another person, to look out for another person. We have a duty of care towards the property of others as well as our own property. So certainly we're not allowed to cause harm. For example, if I light a fire in my own yard, then I have to be careful that the air, or in my own field, I have to watch out that the wind will not carry this fire into a next door neighbor's field. That is something which is, I think, a fairly basic requirement. Well, I mean, once again, this is a basic kind of damage. But then because there can be a very high likelihood of damage. Or if I let my child, for example, carry a burning torch That is an act of negligence, of serious negligence, which can almost certainly lead to the harm of other people if the child is not watched. So starting a fire in my property and not watching it properly, giving a fire to a child to carry without supervision, these are acts which would be prohibited as damages and have to be compensated as damages according to the second view of the Noahide law. Now, okay, so I'm just wondering, shall I pause here for a few minutes to see if there are any questions up till now, Leo? What do you say?
Yes, Rabbi. I think we should be pause for like 5 minutes and then over questions to the audience. Bapak Ibu saudara sekalian, sampai dengan saat ini tadi ada beberapa hal terkait dengan lanjutan daripada penjelasan tentang hukum larangan mencuri. Apakah ada yang ingin ditanyakan sampai dengan saat ini sebelum kita mencapai bagian akhir tentunya? Ya, silakan Pak Valen jika ada yang ingin ditanyakan.
Ya, terima kasih Salum Morelio. Saya
ya,
ingin bertanya begini. Misal kita ini dalam artian kita nih ya. Kita ini istilahnya mengklaim, misal begini, gelar, misal kayak gini, sebenarnya kita bukan arsitek, tetapi kita mengambil gelar itu untuk kepentingan pribadi. Apakah itu bisa dikategorikan pencuri?
Oke. Misalkan ya, kita bukan dokter, tapi kita ngaku-ngaku dokter untuk untuk mendapatkan keuntungan finansial, seperti itu ya?
Iya.
Baik, oke, saya tanyakan kepada Rabbi. Rabbi, the question is, how about title? For example, I'm not a doctor, I'm not a physician, but I took put into my name, and I claim I'm a physician, and I cure people, I administer medicine to the people for the benefit of financial benefit or for myself. Is that included in the category of thieving, stealing, or how is it?
Well, I would say certainly there are two things. One is it is fraud because the person believes that they're paying for the services of a doctor, right? And they're not getting the services of a doctor. So that is, that is in many ways like if I go to a shop and I ask for bananas and they sell me apples. I'm not getting what I asked for. That's a deception. That's number one. The second thing is the second thing is that it could possibly cause harm, because if the person is not qualified and prescribes wrongly, right, a treatment which is not right, then that could be a direct form of harm, of damages to the other person, and on that ground also be a liable act. So the answer is yes. To offer services which one's not qualified and can't perform. That could be now. I mean, it could be sometimes, perhaps, that a person has to step in because there's no alternative and there's no other form of help available. But even then, we have to make sure that there's no deception, and that the person knows, and that both sides know what's being offered, and whether this is a qualified individual, not a qualified individual.
All right. Oke, so ada lagi Bapak Ibu Saudara sekalian sebelum kita lanjutkan? Atau cukup?
Ya, salam Leo.
Silakan. Siapa ini? Billy.
Ya.
Siap. Silakan.
Kalau orang berhutang kepada kita, apakah kita wajib untuk menagihnya atau membiarkan saja? Kali aja dia lupa. Thank you.
Oke. Nah, terus kalau misalkan lupa dia gimana gitu? Apakah orang tersebut masuk ke dalam kategori mencuri gitu ya?
Apakah kita wajib, ya itu juga boleh, atau kita sebagai yang dipinjemin itu wajib menagihnya atau tidak gitu.
Oke.
Thank you, bro.
Oke. Alright, Rabi. Pertanyaan the second question. If we lend money to a people, if we lend money to a friend, for example, do we have the obligation to remind them and to ask for the for him to return? Is it allowed, or we should just let my friends remind by themselves, or how is it? What is the correct way, the correct action we should have in that case?
Right. Well, in Jewish law, there is a prohibition not to. There's a mitzvah, commandment, not to press a person when you know they can't pay. Lo yigois. However, even in Jewish law too, the law is that if you make a time for repayment, then that is, and the time comes, then that's it. You do not have to have additional pity on the other person. If the agreement was that the money will be repaid by a certain time, then that is then there's no. It is completely legitimate to require the money to be paid at the time that the loan was due to be repaid. So I suppose if the loan is due, then you certainly are allowed to remind the person and to collect it. There's no issue about that. It's a good practice, actually, I would think, that when money is lent, one should specify a time when it should be repaid. And if it's a lot of money, ideally with all money, we should have some sort of a written agreement, but particularly with a large amount of money, and particularly with a significant amount of money. So that's, I mean, I don't know, does that answer the question, or is it?
Yeah, but you were saying in Jewish law there are those two, but is that also applicable for us as a Noahide?
I have to be honest with you, I need to check that law, when that law applies. But when we say lo yigos ishis chaveri, there are times when I need to check it myself to find out what the parameters are. I'm not at this particular point. I don't recall what the exact tradition is, but there in Noahide law, you are allowed to require repayment of the debt if it is due. There's no question about it, in my opinion.
All right. Okay, Rabi, I think you can continue your part, and then we can conclude with maybe one or two more questions at the end.
Okay. Then, and if you like, at the end, we can have a time where people can ask any questions if they like.
Sure.
On any.
Sure.
Okay. Sometimes I can't answer everything on the spot. I have to check. I have to be able to check it.
Yeah. Okay. No problem, Rabi.
All right. Okay. Now. Okay. Okay. Now. All right. So. It's so sorry, somebody asked me somebody?
No, it was just a disturbing sound, a noise.
Okay. All right. Now, basically speaking, just to wrap up that last section, society seems to have taken upon itself now the notion of what's called a duty of care. In other words, where there is foreseeable harm, one is responsible for guarding one's property that doesn't cause harm. If you've got a dog which is a vicious dog, you're responsible for seeing that that dog does not harm other people. So this is that's basically where society is now. You have to make sure that your property does not damage neither you nor your property nor your animals, your machinery, etc. damages people. I presume that would mean also that if a person has a factory and there's dangerous machinery in the factory, that the employees have to be to some degree protected from harm from the machinery itself. Okay, now we're going to come now to a further area, which is once again, it is we're talking here again about not just there's harm and there's cares. On the one hand, there's the negative side. We're not allowed to harm another person. On the positive side, do we have an obligation to actually go out of our way to care for others, and to what extent and where and how? Now, one of the areas is there is a concept of oino, which means exploitation, overcharging for a night. Now, according to the baseline view, this law doesn't exist in Noahide law, but according to the second view, it does. And we find that society is in fact maybe moving towards it. Here we have the issue of the question of overcharging, or we call it price hiking or price gouging. This is very different from outright theft, because it is, we can say, this is just the marketplace. The market means that the market has a law of supply and demand, and the price varies according to the demand very often. But still, the question can be asked: is there a point at which the demand which the supplier takes excessive advantage of the demand for an object and makes the price unreasonably high? In other words, what about, is there a concept of fair prices in Noahide law? Now, there are situations where you have monopoly behavior, which can result in an unfair price. I'll give you an example. In Australia, in Australia, we have two huge supermarket chains, and it's a duopoly. There is some competition, but by and large, the market is dominated by two enormous chains of supermarkets. Now, these supermarkets themselves were able to buy up the produce of whole farming industries. And they were able to buy harvests in advance. And what they could do very often is that they could squeeze the producer. So, for example, they could, because they themselves have such tremendous buying power, they were able to go to the dairy farmers, the people who have cows which produce milk, and say, you must sell us a liter of milk for this price. And that's all we're going to. That is what we're going to pay for you. And because they have so much of the market, the farmers were forced to sell their milk at a very, very cheap price, to an extent that it affected their very ability to make a living. So that it could be asked that is an exploitative behavior. Once again, it's not theft, because it's all done through supply and demand, economic law, economic relationships. But still, it is regarded as exploitative, as taking advantage is taking advantage of the of other parties. So this is a or wherever there is, wherever the market, in other words, extracts an unfair price, that is a form of exploitation, which is it's a complicated area. Now that exploitation is prohibited according to the more stringent view in Noahide laws. So the answer, even though the baseline is no, we can't ban such behavior because it is, after all, the operation of a free market. But according to the second view, it is something which society could operate into, legislate with, to ensure fair competition. Now, I don't know. In Indonesia, let me ask you, Leo, is there legislation to keep down, in other words, to allow prices to exert some kind of control over prices of basic commodities? Does that exist? Are you aware of it?
Yes, definitely. Our government is control the 9 basic commodities and then regulate the price. So there is no parties anywhere who can hike up the price or put the price by itself. Like, for example, we are heavily dependent on rice. Rice is our main food here, right? And then the government is basically put the retail price, and each of the stores, each of the supermarket cannot sell more than whatever recommended by the government. So we have that, Rabi.
Well, that is consistent with Noahide law.
Yeah.
That you can't, to prevent exploitation on the market. So there you are. Now, and the question is whether 9 is enough, or whether you have to worry about other areas. Exactly. Do we need to be careful that there's not exploitation in other areas as well? Certainly, in the area of matters which are, as you say, basic and vital commodities, it's appropriate that the government should be involved. The question is whether it should be involved in other areas as well.
True.
Okay. Now we're coming to another area once again, where the requirements are more sophisticated. In other words, they're not so. Now, this is the question of taking interest. Now, taking interest, you all know what interest is. Quite simply, interest is a rent on money. A person lends $100 and wants $120 back. Well, the whole society is operating very much on interest. It's the rental of money. Now, according to baseline Noahide law, it is permitted to take interest. Because it is quite a normal and a natural thing, even though interest can be exorbitant. Interest can bite, and the Hebrew expression for interest is neshech, something which bites at a person, it consumes. Now, there is one view which says that, as in Jewish law, in taking interest is prohibited. Not allowed to take interest from another Jew in the community. The question is a Noahide, does it imply also a Noahide law that one Noahide is not allowed to take interest from another Noahide? There is one view that is so, but it's not the basic view. In many ways, you could say that the prohibition of interest is a compulsory kindness. It's not, because taking interest is such a natural thing to do, and after it's the rental of money, that it shouldn't be prohibited. But the reason why, and if you don't, so what you find very often when is that you do find, for example, in a Jewish community, that there is what's called a free loan fund, where money is lent without interest. Now, there are ways in which, even in Jewish law, in which the borrower and the lender can form a partnership which enables the lender to derive profits also from the money which is lent. There are devices which allow it. It's quite complicated. I won't go into it all here. But in general, the idea that an interest is prohibited in Noahide law is not true. it is permitted in Noahide law to take interest. We can only hope, however, that that interest will not be exorbitant. It will not be excessive and destructive. Okay, now, so there we come to an idea, because the prohibition on taking interest is not simply a matter of preventing harm to the other, it's a question of confirming benefit on another. It is a kindness for me to lend money to somebody else without interest. It is a kindness. It's not just the absence of harm, it's positive kindness. But the question is, does Noahide law require that? And the answer is that basically it does not require it. If people want, now we come to another area where once again, we're not talking about harming another person's property, and certainly not taking away another property, but we're talking about acts of compulsory concern and care for other people's property. For example, lost property. Is it compulsory? Is it in a sense an obligation to return property which another person has lost? Now, in Jewish law, there is a commandment to return lost property. But in Noahide law and in widely, it is not included in the law of theft an obligation to return lost property. If you find a wallet in the street, then you do not have to look for the owner. But it is certainly a desirable thing. Nobody's going to be punished perhaps for not returning lost property, but it is a highly desirable act to make efforts to return property which has been lost by one person to the owner. And in fact, you can see that that the society approves of such action and praises such conduct. So we're going now into a whole area now of positive concern for other people's property. No longer are we talking about stealing, tricking, deceiving. No, now we're in the area of concern for another. Then we have the issue of fairness. Now, here's a question. What about the idea of, once again, a competitive market? And we're not speaking here about the idea of whether there's price hiking. But what happens if a new shop wants to open and it will take away the livelihood of existing shops? For example, you have a little village and you have two bakers, two people who bake bread, or whatever it is. Maybe, as you say, you have rice. Maybe bread is not so common. I don't know, a basic, whatever it is, some sort of, here in Australia, a baked bread is our staple, not rice. And so you have bakeries. And in the Jewish community, we have bakers who bake kosher bread. Now, if you have two bakers in a certain area, and a third baker comes in, and that third baker could possibly disturb the livelihood of the other two, is there a question here of encroaching on the livelihood of another? Do we say it's not fair to come in and compete with the others? So the answer here is that in basic Noahide law, you don't have to worry about this. If competition is competition, but there is a but if on the other hand there are certain forms of behavior in competition which are which are highly undesirable. For example, we call this something called predatory pricing. That is a very ugly behavior, where a big business could lower its prices to such an extent that it crushes a small competitor. And then once the small competitor has been driven out of business, it brings its price up again. That is a form of behavior which society ought to regulate. It may not be required by basic Noahide law, but not basic Noah law does need to be think about the livelihood of others. We have to think about others. It's not just not just for us to be protected from harm, but for us to think about the livelihood of another person. Is my economic behavior harming in some way? So there are a whole group of areas like this, and then finally we come to things like greed. Well, greed is not something which you can prohibit. You can't punish greed, but we know that greed is a very undesirable characteristic, and greed is something which leads to all sorts of suffering, and so on. It says that as I mentioned at the very outset of last week's session, that the global financial crisis of 2008 was the product of greed. So even though you can't punish a person for being greedy, but you know that greed is the source of a lot of evil. And then finally, we come to ideas like charity and love of a fellow human being. And this is not just, this is where it's not just my own property is protected, but I go out of my way to care for another, to see that another person has their needs met, to give charity, to love another human being. These are obviously very, very important things. And if we have this, then we can be sure that we won't come to all of these phenomena of harm and theft and so on and so forth. If our attitude is the attitude which says this other person is a person whom I need to care for, just as I care for myself, and that they are a human being with needs, just like I have needs, then that's going to eliminate, hopefully, a great deal of undesirable harm and in the realm of property and person. Okay, Leo, now I tell you, next week is a Jewish fast day. So yes. I don't think that there will be, I will be giving one, but the Sunday after that, please goodness. Okay.
Yes, Rabbi, no problem. So we can stop for next week, and then we can continue the next week after the Jewish festival.
Right. Now, look, I do apologize. I also said there could be time for questions, but I just don't know if I have time now because, so maybe, and this is a very burning question.
Yeah, one question, Rabbi. Just one question.
Right.
Pak Valen, silakan. Pertanyaan terakhir. Satu pertanyaan terakhir.
Oke, terima kasih Morelio. Misal begini, di depan rumah saya nih ada pohon, tapi itu bukan milik saya. Pohon itu pohon mangga gitu.
Punya tetangga gitu ya?
Enggak, ini kan tetangga saya juga pernah saya bertanya kan, bukan istilahnya itu udah ada gitu, tapi pasti ada pemiliknya.
Tapi di tanah orang lain atau di tanah umum? Di
tanah umum.
Oke.
Pasti terus, itu kan ada pemilik kan.
Ya, pertanyaannya.
Ketika gua bertemu dengan pohon tersebut, pohon itu kan pohon mangga, More. Dan ketika gua bertemu pohon tersebut, gua ngelihat pohon itu nggak ada buahnya gitu. Apakah boleh kita sebagai Bene Noah istilahnya marah kepada pohon tersebut karena pohon itu nggak berbuah?
Terus marahnya gunanya untuk apa?
Menebang pohon itu karena itu bisa
dipangkas gitu ya, ditebang ya. Oke. Alright, Rabbi, there is one question here. It is like, for example, in our house, in my house, for example, in front of my house is a public land. It is not the private property, and then in that land, it happen to be public. There is one fruit tree, for example, a mango tree, like over there, and then the mango tree is not bearing any fruit at all, and we don't know who planted that. Of course, there will be someone who planted that, but we don't know, and we were not able to retrace it who planted that in that public property. So for us, since for me, since the tree is in front of our house, can we just cut down the trees since it's maybe disturbing to my house?
Are you saying, do you have permission to cut it down?
Yeah.
Well, the problem is that the question there is that now that tree is now in it's in a public domain.
Correct.
So the question is that tree has been around for quite a while, has it? For years.
Exactly. Yes, definitely.
Okay, so it could be that tree now actually is property which belongs to now, because it was to the council, to the city council. So the question is then whether you can first. So the next question. So that there is an owner. The owner of that tree is the council, right? That's number one.
Right.
So number two is that tree. You said that tree is that tree a disturbance to you or not a disturbance to you?
Yes, definitely.
It's blocking your light. It's blocking your view, or something of that sort.
True. Exactly.
Well, then I think in this particular case, so let me ask you, how long ago was that tree planted?
We don't know, but it's there.
And then did your house come first? Did you come first, or did the tree come first? Did you come to that place first, or was the tree there first?
My assumption is basically the tree is there before I moved to that house.
The tree moved there. Okay, so there is then an issue there also of whether there is the tree. It's called a chazaka. Whether because the tree was there before you came.
Yeah.
Whether in fact, therefore, that is something which you can't claim, which you can't remove. You could, if you were there first, and then they planted a tree in such a way that it darkened the light, stopped the light coming into your house, then maybe you could make a claim. But if the tree was there before, then there is a question. I mean, unless there was a different owner, the other owner didn't make any difference. It's a problem. But practically speaking, you should certainly, also because these laws are not necessarily laws which are binding in Noahide law. What you need to do in that particular case is go to the council and set out your objections.
Disturb, yes.
So that is the way. And try through the laws, the local laws, get the matter resolved.
All right. Yep. Very clear, Rabbi. Thank you so much.
All right.
Thank you so much, Rabbi.
See you in a fortnight, in 2 weeks, please. Goodness.
Yes, Rabbi. See you fortnight. Thank you so much. Shalom. Shavua Tov, and have a nice day for you, Rabbi. Bye-bye.
Rabbi.
Oke, jadi saya terjemahkan tadi dengan untuk jawaban terkait dengan pertanyaannya Pak Palen ya. Jadi ini sebetulnya bukan sekedar pertanyaan yang simpel dan kondisi yang simpel gitu ya. Nah, tadi Rabi juga makanya tanya dulu apakah pohon mangganya itu siapa yang duluan di situ. Memang pohon mangganya itu kan ada di ranah publik ya, di pinggir jalan gitu kan. Itu bukan properti milik umum, bukan properti milik seseorang gitu ya. Kalau properti milik seseorang misalkan di sebelah gitu ya, rumah pekarangan kosong sebelah, kita tahu pemiliknya ya, kita bilang kepada pemiliknya, Pak, ini pohon mangganya mengganggu. Ini udah masuk ke rumah saya potong ya, saya minta izin. Itu simple gitu kan. Nah, kalau di publik ini agak repot gitu. Tadi Rabi makanya nanya siapa yang datang duluan. Pohon mangganya itu nongol duluan atau kita yang datang di situ terus tiba-tiba mungkin ada yang melemparkan biji mangga ataupun ada yang sengaja menanam. Nah, kalau kita yang ada di situ duluan, maka kita punya hak untuk berkata ini publik fasilitas publik, tanah publik, tolong jangan ditanami. Karena kalau ditanami saya terganggu, rantingnya bisa merusak genteng saya, daun-daunannya juga bisa rontok, saya juga nggak ada waktu untuk membersihkan. Boleh seperti itu jika kita datang duluan. Tadi Rabi bilang begitu kan. Nah, kalau kasusnya kita nggak tahu, ini tiba-tiba kita datang di situ sudah ada pohon mangga, tapi juga ditanya siapa yang punya nggak jelas gitu kan. Nah, Rabi berkata tadi bahwa, dan memang ini sebetulnya dijelaskan dalam detil 7 hukum Nuh juga, bahwa apapun yang ada di fasilitas publik, fasilitas umum itu ada pemiliknya. Pemiliknya siapa? Yaitu pemerintah, dalam hal ini Pemda. Ya, maka dari itu jika kita ingin melakukan sesuatu terhadap pohon tersebut sampai ingin pun juga menebang, ya kita minta izin kepada Pemda. Kita bilang aja kepada Pemda, kepada pemerintah kota, dinas pertamanan, kita udah punya, saya yakin setiap kota ada seperti itu. Kita bilang aja, Pak, ini rumah saya di jalan ini, nomor sekian, RT sekian, RW sekian, kelurahan sekian. Di depan rumah saya ada pohon mangga dan itu sangat mengganggu. itu benar-benar berapa kali misalkan merusak genteng saya, daun-daunannya membuat talang air saya mampet segala macam, itu kerugian buat saya, Pak. Maka dari itu mohon saya minta untuk ditebang. Nah, seperti itu. Palingan kita harus minta izin kepada Dinas Pertamanan seperti itu ya. Jadi kita sebagai Bnei Noah ini sebagai Bnei Noah itu juga tidak bisa semena-mena dan tentunya juga harus berjalan ataupun melakukan tindakan kita dalam koridor yang benar. Tadi itu jawabannya Rabi sih. Oke. Baik, Bapak Ibu sekalian, terima kasih pertanyaannya dan terima kasih juga atas kehadirannya. Dan ini adalah bagian terakhir daripada hukum yang membahas tentang larangan mencuri, ya. Nanti kita akan bertemu kembali 2 minggu dari sekarang karena minggu depan itu adalah ada festival Yahudi gitu ya, yang mereka harus puasa, Rabi harus puasa dan berserta dengan orang Yahudi lainnya. Nggak apa-apa, kita akan stop dulu pengajaran minggu depan. Kita akan mulai lagi melanjutkan topik 7 hukum berikutnya bersama Rabi Cowen 2 minggu dari sekarang. Waktu tetap sama, link Zoom juga tetap sama. Maka dari itu saya mengundang Bapak Ibu sekalian semua untuk kembali bergabung bersama dengan kita untuk membahas kelanjutan daripada detail 7 hukum. Baik. Terima kasih Bapak Ibu sekalian. Selamat beraktivitas kembali di hari Minggu ini. Shavua Tov dan Shalom.
Shalom. Shalom.
Halo.